Hey guys, I'm Kate Bihm. I'm a family lawyer in Montgomery County, Texas. And today I wanted to talk to you about the 3 most common objections that I hear in family court. Hearsay is probably the single most common objection in any field of law in the state of Texas. It's got to be. All right, so what is hearsay? Hearsay is when we're relying upon something that a person said outside of the courtroom, and we're offering what they said into evidence to prove that what they said is true. So, where hearsay gets really difficult is that there are tons of exceptions and exclusions from the hearsay rule. And that can be very confusing because there are times when what somebody said outside of court is 100% admissible, provided you can prove that it meets one of those exceptions or those exclusions. But again, where this often gets really frustrating in family court is people want to go into court and they want to say, my kid told me they saw their dad smoking meth, or my child told me that their dad had 8 beers at the bar and then drove them home. But unless it falls within one of those exceptions or exclusions, you're not allowed to come into court and say what your children told you. One of the main exceptions to the hearsay rule or exclusions to the hearsay rule is what we call a statement by a party opponent. And so in a divorce case, for example, the husband can come into court and basically say anything in the world that his wife has ever said to him. And that is going to fall into an exception or exclusion to the hearsay rule. And so that is something that people often rely upon. In cases involving adultery, they're like, well, I don't have any proof that my spouse cheated on me. And I always ask them, I'm like, well, did you confront him about it? And they're like, well, yes. What did they say? Well, yeah, he admitted that he cheated. And I was like, well, that's good. That's evidence. We can bring that into court and we can talk about that. Now, if his side piece came in and told you, hey, I've been sleeping with your husband, that's hearsay, and you may not be able to have that admitted unless it falls within a specific exception or exclusion. So whether you're going to be able to get hearsay evidence into court is, one, an important part of trial preparation with your attorney, and 2, it's going to require that your attorney have a really clear understanding of the exceptions or exclusions to hearsay under the Texas Rules of Evidence, because there are often ways that you can get it in if you can fit it within one of those exceptions or exclusions. But generally speaking, you are not allowed to come into court and say what anybody else has said to you outside the courtroom, except for the party on the other side of the lawsuit. And that can get really complicated, especially in family law cases. But if you have an experienced trial attorney for your lawyer, hopefully they can figure out a way to get it in through one of the exceptions or exclusions.